Mr. Rosen, before you get into your stride again, can I just ask you for reference? We've got the Solicitors Disciplinary Proceedings Rules 2024. I suppose they don't apply in this case because they come too late. What did they replace in respect of what the SRA does before a case gets to the tribunal?
I think the 2007 scheme.
We also had handed up the SRA Disciplinary Procedure Rules 2011, but the 2019 Solicitors Disciplinary Proceedings Rules 2019, which is nearly 40 pages worth, at a quick glance seemed to me to be dealing with what happens once the case gets to the tribunal, but do tell me if I'm wrong.
The predecessor rules were promulgated in 2007, the Solicitors Disciplinary Proceedings Rules 2007. They came into force on the 14th of January 2008.
Right. Then 2011.
I think the next in time were the 2019 rules.
Where's that leave 2011 rules?
The 2011 rules are not the disciplinary proceedings rules. They are the SRA disciplinary procedure rules. So they serve a different purpose. But your lordship's question demands an answer. What was in place prior to 2011?
Well, no. Let me follow it through going backwards. Tab 57, page 1450. Current rules. SRA Regulatory and Disciplinary Procedure Rules. Rule 1, 2. A matter is an allegation that the person has B has committed or is responsible for a serious breach of any regulatory obligation. Right? In the 2011 rule, disciplinary procedure rules,
Yes.
it says, and this is dealing with the SRA does itself, the circumstances in which the SRA may make a disciplinary decision to direct a regulated person to pay a penalty are when the following three conditions are met. The third condition is that the act or omission was neither trivial nor justifiably inadvertent. I don't know whether that is still in force or replaced by the 2024.
It is replaced by the 2024 rules. And whilst I remember, I think I was asked the specific question by Lord Justice Zacaroli as to whether either of the, as to whether the 2011 rules were part of the handbook, and the answer is yes. Whereas the 2024 are not, because the handbook has been superseded by the current scheme.
I think I can add, I hope, to the understanding.
Good.
At tab 57,
Well, at the moment we're talking about the SRA's own rules, not the
Yeah.
tribunal rules. You've got the 2011 rules that you mentioned,
Yes.
which were handed up in full form this morning. And then at tab 57, you've got the replacement rules, and they were actually first made in 2019. They were updated in 2024. And 2019 because that's when the current code of conduct and principles came into force, replacing the 2011 scheme.
Do we have, or does anybody have, the text of Rule 1.2 or whatever corresponded to it in the 2019 rules, which are, after all, I suppose, the ones that applied in this case?
I'm sure we can get it. Maybe the SRA can even more easily, but I'm told by my learned junior, Mrs. Butler, that we can get it from Chambers. The other rules, as I think you already know, are the rules made by the tribunal itself.
Yes.
Under its own statutory power, and I think at tab 56 we have the rules as they've been in force since 2019. That's the tribunal rules.
Yes, Mr. Rosen.
Lords, before the luncheon adjournment addressed you on Pablo and Grindrod, I was about to go on to the specific submissions that have been made on behalf of the firm in relation to Lee Day concerning Approach 2, and the court will recall that Will and Friends place reliance upon a number of paragraphs that begin at paragraph 216 in the Lee Day judgment. They also understandably place reliance upon the fact that at paragraph 55 of the learned judge's judgment, this is page 93 in your court doc, she acknowledges the technical nature of those allegations. Beg your pardon?
The rules.
Yes. The rules under which the allegations were made. So our response to this really falls in two parts. First, it may be another example of assuming a jurisdiction that has no legal basis, albeit by the divisional court. But there may be another answer, and that is that although the breach concerned a technical rule, it was dependent upon a core principle under the 2007 scheme, which does connote inherent seriousness. And to follow this,
I'm sorry, I've lost you. So talking about Mrs. Justice Lang's paragraph 55.
No, I'm going back to Lee Day. So the point is, in Lee Day, the learned friends say that those later paragraphs suggest support for Approach 2. That is to say that you establish a breach, but you can still dismiss it, because although the breach is established, it's not serious enough to merit regulatory action. So the learned friends say, so the argument runs, well, that must indicate that the divisional court accepted that there was a jurisdiction in the SDT to find something breached and then nonetheless to dismiss it. And the reference to the learned judge's judgment was her acknowledgement that there was an apparent distinction in those later paragraphs, in that, unlike the earlier ones, which concerned core principles, these allegations concerned rather more technical standards. And so my second answer to that is that although that's right, that the technical rule under specific consideration, or rather the rule under specific consideration was technical in nature, one has to have a look at I think it probably is best understood by looking at the allegation. So may I invite you to do that, please, in lead A at core bundle, page 1005. This concerned allegations against first and second respondents of authorising the payment of a prohibited referral fee in breach of rules within the Code of Conduct 2007, and there were a number of technical rules that are specified. If your lordships look at the bottom of the page, 902, and later on 9014, and it will not have escaped your lordship's notice that this is part of a cluster of rules. So 902, for your assistance, the text of 9.02 is set out at paragraphs 172 to 175, and it concerns the formalities required in entering into a financial arrangement with an introducer, including that it should be in writing and should contain all relevant information about the introducer arrangement. So technical in nature. 901, 9.01, open bracket 4, close bracket. Again, technical in nature, the prohibition on a solicitor entering into arrangements with certain persons who solicit or receive contingency fees in respect of any claim arising as a result of death or personal injury. That's rather less technical. But, sorry, just pausing there, the text for that is also paragraphs 172 to 175 and 229. 101, we've looked at it in the core principles themselves, but the text is at paragraph 113, is a standard which does connote a seriousness element. It's upholding the rule of law, etc. Paragraph 1.02 is want of integrity, set out at paragraph 80. These are all core principles. 1.06, not acting in a way likely to diminish trust, text set out at paragraph 81. And 8, the qualified prohibition on fee sharing, so something in the nature of a technical prohibition. The hierarchy of rules in the Code of Conduct 2007, I suspect we don't need to go to it because it's obvious, is that the core principles, rather like the 2011 principles, take precedence. And you have that set out in the Code of Conduct 2007, your tab 48 at 1321, and there are passages that bear out that obvious truth in the... Could I invite your lordships to go to page 1324? words may suffice. At the middle of the page, the core duties pervade all of the other rules and we therefore place them at the forefront of the SRA's regulatory activity. And the core duties are then set out at page 1328. So, the point essentially is this, that the contention that even technical rules allowed for the dismissal of allegations is in fact, if one analyses it, in relation to allegations that were not just technical, but were technical rules on the back of core principles. And so we respectfully submit that the cluster of standards that were under consideration did in fact involve standards that connoted considerations of seriousness. And we would draw the distinction with respect to the allegations made against the firm, in that we would say that the top level mandatory principle, Principle 7, is itself a top level principle that is technical in nature.
Sorry, Mr. Dresden, you've lost me. Are you saying that Principle 7 does have an inbuilt requirement of seriousness, or that it doesn't?
I'm saying the opposite. That I'm saying that Lee Day does not suggest. Perhaps this is more an approach 1 than an approach 2 point. I'm saying that Lee Day does not suggest that you can, if you're dealing with a technical type of offence, that you have the power to just dismiss it even though there's a breach. Because the cluster of standards under consideration in those later passages did not just involve the technical rules, they involved technical rules attached to core principles, which themselves had connotations of seriousness. I think I'll move on to my next point, which concerns the SRA's response to the matters that were raised in the letter. And the essential response, if one can take them in turn, first of all, Proposition 1 advanced on behalf of the firm that there was an ancillary powers provision that confers a power to dismiss. I'll give our answer in broad terms, and then, if I may, I'll try to go through the relevant provisions. What we said in response in the Capstick's letter at your tab 13 is that this is an ancillary powers provision in aid of the tribunal. There is a separation of functions. The SDT is limited to deciding whether the rules were breached, and that it cannot confer, as it were, a freestanding power to dismiss, because that would contravene the separation of powers. So may I invite the court to go to tab 41, page 1219. So this is the provision that we were invited to consider whether this conferred a power to dismiss charges. If your lordships cast your eyes down to uh, 46(9)(b), perhaps in passing because it's relevant to the point that we'll come to. 5A, the tribunal may do anything calculated to facilitate or incidental or conducive to the carrying out of any of its functions. 9, the tribunal may make rules, B, about the procedure and practice to be followed in relation to the making, hearing and determination of applications and complaints.
I'm sorry, I don't see where this gets you, Mr. Aisley. Isn't this circular? Tribunal can't say we find that the allegation of a breach of Principle 7 is proved, but we're still going to dismiss it. Any more than a court could. The question is what needs to be shown to show a breach of the principle.
Well, as I understand it, the learned friends on behalf of the firm advance, as do those who instruct them, advance the argument that this is a source for a power by the tribunal to, as it were, step outside the scope of the express rules and to create a new rule for itself which allows it to dismiss charges notwithstanding that there is a finding that they are breached. So I don't think it's a good argument, but I'm seeking to address it.
I think that's what they're saying, but I think he's setting this up to say that they're wrong.
So
Well,
that,
speaking for myself, I don't see how it can be. If, of course, it depends how you formulate the question. If it is sufficient for the SRA to demonstrate that a respondent firm or solicitor is in breach of a legal or regulatory obligation, if they are, then there is a contravention of Core Principle 7. If that is the correct interpretation of what Core Principle 7 means, then the tribunal can't say, we find the allegation is proved, but nevertheless we're going to dismiss the charge. Of course they can't.
well, as I understand it, but I'll no doubt be corrected if I'm wrong, my learned friends say, yes, they can. They can step outside the rigours of the rules that govern their procedure and in effect create a new rule which says you can do whatever you like.
Right. Okay. Well, I think that particular straw man need not detain us long.
Okay. I'm grateful. We have detailed arguments, but they are set out in the letter to the effect that it's an impermissible use of an ancillary powers provision. Proposition 2 is to similar effect that section 46(9)(b), provision we just looked at, confers the power to make a new rule, and we say in the letter, I'm not going to seek to develop it, but it's in the letter, that would be ultra vires, the rule-making power. And what we rely upon as the underlying basis for this, which has a surviving relevance, is that there is a clear separation of powers. If your lordships look at those provisions, section 46 onwards, the tribunal is limited in its functions to the determination of allegations that are brought before it. And as we saw already from section 31 of the Solicitors Act, the function given to the SRA is to create standards, to create rules that regulate solicitors with respect to their conduct, etc. So we say there is a clear separation of powers, and that obviously feeds into matters that I have already raised. So I think without further ado, on ground one, I can move on to ground two. Ground two being, if I can dare to paraphrase, that the learned judge should not have remitted to a fresh SDT that's unjust and constitutes a procedural irregularity. Paragraphs 54 to 62 is where we address this matter in our skeleton. And to a large extent, I've already had the opportunity of addressing the lordships on this point as a result of the helpful questions that were posed to me prior to the luncheon adjournment. We say that the application of the seriousness plus test led the tribunal into error in viewing inadvertence as somehow exonerating, when in fact underlying the inadvertence by the firm itself was a serious default by a senior person performing the duties of the firm. And we sketch out again at our skeleton at paragraph 57 of what we say should have been the proper approach of the tribunal, which should have assessed the level of culpability and the harm caused by the firm's conduct, as well as any aggravating and mitigating factors, in accordance with its own guidance note on sanctions, which the lordships have at tab 64, page 1613 onwards. It's obliged to have regard to its own note as a result of Rule 41, open brackets 4, close brackets of the current tribunal rules in your bundle at page 1438. And as we put it in paragraph 57, we said instead the seriousness plus test meant that the tribunal treated the concepts of seriousness and culpability as coextensive and introduced the irrelevant concept of reprehensibility, and ignored altogether the question of harm, in particular harm to the reputation of the profession and the firm, which is a fundamental consideration when the tribunal imposes sanction.
Can I just ask, why should the tribunal at the stage that they at have had regard to the guidance on sanctions?
I take your lordship's point, It's what would have followed in the event that a finding was made against the firm, so it did not arise at that stage. I'm just pausing to reflect on whether it nonetheless has a more general bearing on considerations of seriousness. Of course, we say that seriousness didn't come into play at all at this point in the proceedings with respect to the standard that was articulated. But I suppose the argument would run that if you are going to have regard to considerations of seriousness, it would be a strange thing not to have regard to the way in which you calibrate seriousness yourself for the purposes of sanction. Nonetheless, I take your lordship's helpfully made corrective point. Then we say, in the same paragraphs in the skeleton, that the deterrence required a finding, and this is the Gould analysis. My learned friend took the court through those passages in Gould and commented upon them yesterday. The starting point is what the judge said. As my learned friend rightly indicated, we relied upon the Gould analysis in our speaking note, in fact, and oral submissions. And the learned judge adopted the Gould analysis at her paragraphs 75 to 76.
Can we look at that?
Yes. Pages 99 to 100 in the call bundle pagination. I'll read it out if I may. The rationale, 75, the rationale of a regulatory provision of this type is helpfully explained by Gould in Chapter 4. He sets out his overall view in the introduction of 4.1 to 4.2, that a rule breach may justify a significant penalty for the purposes of deterrence and public confidence without the need to show that any individual is culpable or that systems are inadequate. Although he accepts at 4.9 that most rules are drafted in terms which require misconduct in order to be breached. He states as a general proposition that some rules may be breached without the need for fault on the part of the entity or person responsible for compliance with them. He cites Hazelhurst, which was an appeal against sanctions imposed for breach of the accounts rules, in which it was common ground that they were strict liability offences per Mr. Justice Nicola Davis. It was cited with approval in Bass and the SRA. Then at 4.16 to 4.21, Gould argues that a firm's liability may arise from the breach of rules by an employee without fault on the part of the firm or its principals, and refers to breaches of the accounts rules in support of this view at 4.16 and 4.17. 76. I do not consider the results of the SRA's interpretation of Principle 7 and Outcome 7.5 are anomalous or unfair or disproportionate, as Mr. Coleman King's Counsel submits. If that is the view of the profession and the regulator, then the solution lies in an amendment to these rules, etc. So we read 76 as it were, as deriving support for the view that they're not anomalous or unfair or disproportionate from the analysis at 75. I suppose one should perhaps go back to 74, which sets the context for it in describing the MLRs themselves as being analogous to strict liability offences. It's fair to say that the main thrust of our submission was not that the MLRs were strict liability offences, but rather that P7 and 07.5 riding on the back of the MLRs were.
I think you say that they're strict liability offences, whatever the underlying legal or regulatory breach. We go back to my fire extinguisher.
Maybe the time of day, I'm not quite sure which target you're currently addressing, because ground 2 is 2 options. The tribunal ought to have, this is on the assumption that the judge was right.
Yes.
So there is a breach of Principle 7.
Yes.
That's been found. So all that's left is sanction, and that's the 2 options are the judge ought to have said, well, no sanction because the finding that it's inadvertent covers that. Secondly, all that's left is sanction. Now, at the moment, are you on the first bit only?
Well, what we are seeking to attack is the finding by the SDT that inadvertence means that it's not serious and that no sanction is required.
So it's the sanction. You're objecting to their proposition that if it's remitted on the basis the judge was right,
yes,
that there should be no sanction.
Yes, because we're saying that the error in applying the seriousness plus test, it infects the entire assessment. So you can't be bound to sanction on the basis that inadvertence is a matter that means you don't need a sanction. Yeah. To the contrary, you do need a sanction for deterrence, and you do need a sanction because inadvertence doesn't get the firm off the hook. Because they may have been inadvertent, but their senior member of the global firm, who they allowed to tread the pathway of due diligence and ongoing monitoring in their name, was seriously culpable.
So I think you're agreeing with their second proposition then. If it is to be remitted, it's to be remitted to consider sanction. Because there's no need to consider breach, that's now accepted.
Yes.
But the level of seriousness is up for grabs within the sanction context.
Yes. Although we say, we didn't say it to the court, my learned friend is quite right. We said, decide it yourself. That was the I think agreed position. But obviously we've had the luxury of considering the judge's reasons subsequently, and we say that she was right, that you just can't disentangle the error, and that that the better approach is to consider the matter afresh, not limited to sanction. I'm going to move on, if I may, to ground 3.
Oh, before we leave ground 2, if the case has to be remitted, are you saying that we'll leave principle 6 and 8, that's ground 3, we're coming to that in a moment. At the moment focusing just on ground 7, the judge seemed to be envisaging that principle 7, that the case should just start again.
Yes.
Why?
think her reasoning, the learned judge's reasoning, was that which I've sought to set out, that the error that was made in applying the seriousness plus test, when indeed no seriousness test applied at all, so infected their conclusions that the essential conclusion leading to the question of liability ought to be considered afresh by a tribunal that was not misled by that misapprehension. And we respectfully see the force of that observation.
Yes, but why should a tribunal, and no doubt cases remitted, we would say it should be to a fresh tribunal, and I dare say Mr. Coleman would say no, the same one, as happens in these cases. But whether it is the same one or a different one, why shouldn't the findings of primary fact, that is what happened, not stand? Otherwise you have to have another 6-day hearing with expert evidence as to who did what and when and what was Mr. Chatto's position and so on. Why?
Well, as a matter of candour, the parties exchanged extensive and detailed supplemental written submissions for the court on the question of consequential matters, as this court would expect. And our position, as I recollect it, was in accordance with that which your lordship articulates. I think the learned judge took a different view, which was that the tribunal had just gone badly wrong in its entire approach.
Right, all right. Then ground 3.
Ground 3. The point in relation to ground 3, which we sketch out in our sketch is that as a matter of fact, the P6 and P8 issue was expressly reserved by the SRA as a matter that would arise for consideration as a consequential issue if it was successful in its principal submission. And could I invite your lordships to look at tab 7 in the core bundle, at page 141. SRA's skeleton argument at the high and the lordships will see conclusion 44, for the reasons set out above, the SDT decision should be set aside. 45, the SRA does not invite the court to remit the appeal to further hearing before the SDT would not be proportionate. The previous SDT made all the necessary factual findings, including the finding that allegation 1.1 was proven and regulation 14 of the MLR's 2007 was breached. If this appeal is allowed, that should be sufficient to establish a breach of Principle 7 of the 2011 Principles and Outcome 7.5 of the 2011 Code. The only question would be whether there was also a breach of Principle 6 and or 8 of the 2011 principles, what order to make in relation to sanction, 2, and 3, what order to make in relation to the cost before the SDT and on this appeal. So we say that there is no doubt that the issue was reserved. Obviously, the point, the approach that was being sought, or the approach that was being submitted for before the judge was that if she allowed the appeal on the principle, she should grasp the nettle herself. And it's also right, set out in the consequential written submissions, which we've not placed before the court, that there were solicitors' letters before the hearing came on, an open email communication with the judge that reiterated that position adopted by the SRA. So we say that P6 and P8 remains to be determined in the event that the judge was right in relation to P7 and 07.5. And the logic of the matter is obvious, that if you breach P7 and 07.5, given that we're dealing with the same conduct, it is relevant to the assessment of whether P6 and P8 breaches have occurred.
What did the tribunal say about Principle 6?
I think the gist of the matter was that there being no breach of P7 or 07.5, same conduct could not be said, given the inadvertence of the firm, to give rise to P6 or P8 breaches.
Where do we find that?
Yes. The key passage, I think, I'll be corrected if I'm wrong, oddly enough appears in relation to the cost determination. It's a peculiarity of the SDT's decision that it spent, in a very long judgment, a large part of the judgment summarising the submissions made to it, but dealt with its own findings in about 2 to 3 pages, including in the course of the cost submissions. If your lordship goes to page 248 in the bundle, it sets out Maloney Friends Butler's submissions in relation to costs, which the tribunal accepted in full at paragraph 16, and they include the SRA did not take into account the Law Society's practice note, and then 2, in relation to principle 6, there was no allegation of manifest incompetence. And in relation to principle 8, the SRA had at no stage made any criticism of the firm's systems and controls, and nor realistically could it in a context in which its own audit of the firm in 2014 found that those systems and controls to be the gold standard. So it follows we would respectfully submit that the errors in relation to treating inadvertence as wholly exonerating infected the finding in relation to certainly P8 and we would say also in relation to P6, focusing on the firm's inadvertence as opposed to the quality of the conduct of their delegate, Mr. Chateau.
That wasn't an appeal point, though, was it? There was an error in the tribunal in failing to recognise that the firm had relied on Mr. Chateau and not taking that into account. That wasn't appealed, was it?
It was reserved in the way that I have described. But, it was not, yes, but it was not the subject matter of a specific ground of appeal.
Yeah.
I accept that.
And my lords, my learned friend invited me to say if I disagreed that was where the tribunal dealt with principle 6 and 8. I mean, it deals with it to the extent my learned friend said in relation to cost, but also in the main section on misconduct on the previous page, because you see from paragraph 9.378, the tribunal says it considered whether the firm had breached their principles and the code. And we would invite you to read that entire section on the heading of misconduct as addressing not only Principle 7 and 7.5, but also Principle 6 and 6 and 8, as the tribunal was required to do.
And it's all based on the breach of the Money Laundering Regulations and what they had and hadn't done.
Yes.
Yeah.
Speaking again for myself, I can't see the allegation of Principle 8, which is running an efficient practice or something like that, what that adds to the case at all. Principle 6, maintaining public trust, does add to the case, but tribunal just don't deal with it, or it's kind of swept up in the conclusions. Right. Anything else on round 3?
No, I don't think so. I'm just reflecting on your lordship's last point. There are circumstances in which technical breaches can nonetheless, in terms of sanction, have regard to questions of greater culpability. So I'm just reflecting on whether it would be open to the tribunal to have regard effectively to the same breaches on a simple finding of a breach of P7 and 07.5. So following your lordship's line of logic, would it make any difference? I suppose it would make a difference because part of the purpose of establishing a breach of a principle is to have a declaratory judgment available to the public to understand the nature of the defaults that have occurred. So I'm going to move on to ground 4, which is the question of whether the judge was right to award the SRA the costs of the proceedings before the tribunal. To some extent, that may be bound up in the question of whether there is to be a rehearing. Certainly, if there is to be a rehearing in accordance with the judge's direction, we would respectfully submit that that is the right order, for the simple reason that it must follow A, that there was a serious error of law that was made by the tribunal, B, that the firm was completely responsible for the error because the tribunal accepted bag and baggage, as I put it earlier, the very detailed submissions that were made on behalf of the firm. So the firm induced the tribunal to make that error, although tribunals should be resilient enough and able enough to resist such inducements if they're wrong inducements. But the net result is that there would be 2 hearings. The first one was a complete waste of time as an error. So the question is, who should bear the costs of it? Why should the profession as a whole bear the costs of it when the firm has the resources and is responsible for the wasted costs?
You accept that if Mr. Coleman wins outright, then the order for costs can't stand because
That must follow.
if we allow the appeal and restore the order of the tribunal dismissing all the charges, then it couldn't be right to order Dentons to pay the costs. If the order of this court would be that the case had to be remitted, but only for certain limited purposes, not for 6-day rehearing, as it were, then what would the consequences be for the order for costs made by Mrs. Justice Land?
Well, it would follow, I suppose, that some useful work had been done in the course of the first hearing in getting to the stage of establishing the factual matrix which should be applied for the purposes of what is left of the proceedings. And the appropriate order may therefore be modified to take account of that fact. If we were to reach that stage, it may be that the more sensible approach would be for the court to invite consequential written submissions by the parties.
Right.
My Lord, I'm going to endeavour ahead of time, I note, to deal with some of the discrete points that your Lordship gave us to consider.
Yes.
Because I've got some responses to them. But before I do that, may I just take the luxury of turning to those behind me to see whether there are any points that I have that I may benefit by developing further.
Yes, of course.
Lord, there were 2 points, if I've remembers rightly, that required an answer. One was, my Lord Justice Bean's question about the standing of the authorities that were cited in the case of Walker at paragraph 12, whether they remained good law, and to find my note in which I have an answer to that. Switch to a digital version. I'm told by those who've had the time to look into this further, for which I'm grateful, that Felix and Price, I think that's how one pronounces it, remain good law. That insofar as Rao and Silver purport to decide that a finding of serious professional misconduct against a doctor by the GMC required more than a single incident of negligence, they've been held to be wrongly decided in Campbell, for which the citation is 2005 EWCA Civ 250 at 40. Pausing there, the best guide to what is now required in relation to serious professional performance is, I think, to be found in the dictum in Calheim, which we cited and referred to in our skeleton argument. Mandy remains good law and is oft cited. The Scottish cases,
excuse me,
particularly the Scottish Legal Complaints Commission case, has subsequently been approved in a number of cases in 2016 and 2020, and so appears to remain good law. Perhaps rather more broadly, just to make a point which joins together with our earlier submissions. These are healthcare and Scottish Law Society cases which are concerned with the stigma and sanction of a finding of, quote, professional misconduct. So we respectfully submit that they don't carry across to the different scheme of the SRA. The second point that Lord Justice Bean also invited us to consider was the question of whether there is any example, any instance of the SDT finding a matter proved, but making a punitive cost order against the SRA on the basis, in effect, that it was a case that was ill-founded and possibly should not have been brought. to our knowledge, that there isn't such an example. I have, however, been referred to a recent decision, in fact, one in which our friend Miss Butler appeared, which is SRA and Stern, 2025 decision. It's not quite on point because the SDT dismissed all the charges, but certainly one of the grounds that was developed by Miss Butler in support of her cost application, applying the usual Baxendale, Walker, etc. Criteria, was that the proceedings had been brought on an improper basis. And for what it's worth, there was an order of costs that was made. So these are arguments that are raised and that the tribunal is entitled to take into account. So I think, unless I can assist your lordships with any other particular matter, we stand by those submissions.
Thank you very much, Mr. Mr. Kelvin.
Thank you, my lord. If I may have my turn with the lecture.
Yes.
Scarce commodity.
There's the second one down there. Is that left hand broken?
Anyway,
Friend,
it's a bit late now.
Yes.
In effect, yes.
Yes.
In
my
short,
friend says it is, and I accept everything he says.
seriously falls below the standards to be expected. My lords, having listened to my learned friends' helpful submissions, may I identify 3 areas of common ground which set the scene for the point of law and perhaps help bring it into sharp focus. 1, it appears to be common ground that as a matter of legal or regulatory policy, only serious breaches of the standards or rules should be disciplined. I say that's common ground because it's reflected in the SRA's own policies and rules in terms of the matters that ought to be referred to the tribunal, and indeed disciplined internally by the SRA. We've given references in paragraph 24 of our skeleton, and you've already seen the key materials. So that's the first important point of common ground as regards the legal or regulatory policy. 2, it appears to be common ground that if one interprets Principle 7 and Outcome 7.5 literally, in the way the court below has done and in the way for which the SRA contends, it's common ground that there may be many instances of breaches that are trivial or at least less than serious and less than warranting disciplinary action. Your lordship's given the fire extinguisher example. One can think of many anodyne breaches. Your lordship's example involved a conviction in the magistrate's court, but actually the rule wouldn't need to be supported by a conviction. Either the SRA or any lay applicant could identify a technical rule breach and bring it before the tribunal. Your lordship's perhaps is wondering why I said lay applicant. The unique feature of the tribunal is that any member of the public can access the tribunal's jurisdiction. It is the only tribunal we're aware of where that is the case, and it goes back again to the link with the inherent jurisdiction of the court, which could be invoked by any member of the public.
Well, any member of the public goes straight to the tribunal.
Yes, any member of the public. Under the rules, the tribunal at the Rule 13 sifting stage can ask the SRA if it wants to take it up and formally adopt the complaint. But if the SRA says no, the member of the public can pursue it. And indeed, if the SRA says yes, we want to take it up, even then, as I understand it, the member of the public can pursue his or her own complaint.
Does this happen much?
increasingly, there's an article in the Gazette recently about the proliferation of lay applications to the tribunal, but it's always happened. Yes,
Is it still subject to the sort of filter process?
no. It's subject to the Rule 13 filter, which is it's got to be
No
certified.
case to answer.
But it's not, and I'll coming back to the implications of this, it's not subject, of course, to the SRA's own internal prosecution test if it's being brought by a lay applicant. And the third important point of common ground, and this is perhaps lost sight of in my learned submissions, is that the tribunal found that the money laundering regulations breach fell below the seriousness threshold in the SRA's own guidance for reporting breaches. That has never been disputed. We made that clear in paragraph 4 of our skeleton argument, that that's how we interpreted the section on costs, read in the context of the previous reference to the MLR guidance. That was our position before Mrs. Justice Lang, and it's never been disputed that that amounted a finding that the seriousness of the breach or the breach was beneath the threshold for the SRA's own guidance of what needed to be reported, and therefore what could be the subject of proper regulatory action.
Can you just give us the paragraph reference?
Yeah, yes, well, it's in the cost section of the judgment. It's paragraph 13, Roman 4, on page 248. Read with paragraph 16 on the same page, page 248. Read with the guidance which was set out at paragraph 9.338 to 9.339 on pages 239 to 240.
Just in case my silence should be taken as acquiescence, as I hope I made clear in my submissions, we say that any assessment of seriousness was tainted by the application of an incorrect seriousness plus test.
Yes, I think we've got that.
Yes, the point.
You were saying 248.
Yes.
Which paragraph?
It's paragraph 13, Roman 4, which is Miss Butler's submission on behalf of the firm. The SRA did not follow its own guidance in bringing the prosecution.
Yes.
Read with paragraph 16, the tribunal agreed in full with Miss Butler's submissions. And those are to be read with the submission that was made to the tribunal to the effect that the SRA had not followed its own reporting guidance, or at least that the level of seriousness was beneath that indicated in the reporting guidance. And that submission was made at page 239, paragraph 9.338, actually through to 9340 at page 240. That's why I took your lordships to the cases for the proposition that tribunal reasons need to be read as a whole in context and so on.
So when it says at 13 Roman numeral 4, that is in relation to not the principles. This was the prosecution effectively in relation to the money laundering regulations themselves.
No, the guidance referred to, if I've understood, is that guidance which was relied on in my submissions on behalf of the firm in relation to reporting of breaches for MLR breaches, and it was set out at 9.338 through to 9.340. So, Lord, I don't accept on behalf of the firm the tribunal has not considered the question of seriousness simpliciter, to use my learned friend's phrase. Nor do I accept the SRA's case that that finding of seriousness is in any way tainted by any error of law. It took the view, and it was entitled to take the view, in its evaluation to facts, that this was a case on its findings of fact that was beneath the threshold for reporting MLR breaches, and therefore beneath the threshold for regulatory action. That's a very important aspect of the decision.
I follow that they're saying on the final page, for good or ill, they were accepting that the SRA didn't follow its own guidance in bringing the prosecution, i.e. as to seriousness. But
Yeah.
I see where there's a finding that the matter was not even serious enough for Dentons to be obliged to report it when it occurred.
Well, the two points. The first is the only guidance that can be being referred to here is the reporting guidance at 9338. What the tribunal must mean is that on the findings they have made, as the facts now established following a 6-day hearing, the conduct was beneath the level of seriousness indicated in the reporting obligations. Now, for the purposes of the tribunal, it's not so much at that stage as to whether anything should be reported. The focus here is seriousness.
Yeah.
And that can only be understood as a finding that having found all the facts, the level of seriousness was beneath the level indicated in what needs to be reported. Because when you look at the reporting guidance, it looks at considerations such as whether the breach was intentional or reckless, whether there were systemic issues, whether there was hallmarks of money laundering activity. All of those features on the tribunal's findings were absent, and that was the submission I'd made to the tribunal at 9.340. They clearly accepted, if any sense can be made of this part of the judgment, this is the only meaning available, which is that having found the facts, the seriousness fell below what was required to be reported.
Was any other guidance cited in the tribunal?
Not in relation, we'll have to double check, as far as I can recall, not in relation to the seriousness threshold, if I can use that shorthand. There was other guidance about what you needed to do to comply with the MLRs and so on, whether you needed to get evidence, and if so, what sort. And Ms. Butler, who recalls the submission she made because she's got her notes, reminds me that her submission was specifically made by reference to those that part of the guidance.
Do they deal with it anywhere else in the?
No. Well, the only other part, all we've got is the composite phrase at 9.380. But
Yes.
But my submission is that if one is faithful to the findings, which have not been appealed, and if one reads them in context and fairly, as we are directed we must as a matter of law, it can only mean that the tribunal thought that the breach was not serious. Full stop. Also not reprehensible and culpable, but not serious. And, my lords, can I just make this related point also? The submission that I made 3 times by my account as recorded in the submissions was that the breach was not serious, reprehensible, or culpable. Not and culpable, or culpable. And you see that at pages 204, 238, and 240. Perhaps it's worth just looking at the way it was put. Firstly, at 204, just above the hole punch, the last bullet point, you've got the or, not the and.
It's quite difficult, isn't it? Because it's one of those cases where or might mean and in the context. I mean, you were saying it's none of these things.
I was saying it's none of these.
You had to establish that it's none of those things.
Yes. Well, I was saying it was none of those things. In a sense, whether the tribunal meant and or in 9.380 doesn't matter in the light of what we put over the page at 13, Roman 4 and 16, which makes it clear that they thought on the basis of seriousness alone, the seriousness threshold had not been met. So that's the setting of the scene. Now, There is, as I say, an issue of regulatory or legal policy, at least I invite you to consider that there is, that one being, and this was the first point, that a solicitor or a law firm ought not be the subject of disciplinary action in respect of conduct that was beneath a seriousness threshold. As I say, I say it's common ground, this is reflected in the SRA's own materials. And the answer, insofar as the point of law can address or mitigate that problem, the answer given on the point of law must be one which fits or can address not only, of course, the particular breach of the MLRs in this case, or indeed in other cases, but all breaches of all legal and regulatory obligations and legislation relating to a solicitor's or law firm's practice and business. And the parties between them have offered three potential solutions to this problem of legal or regulatory policy, namely that firms or solicitors should not be subject to disciplinary action for less than serious breaches. Two of them have been offered by us, which is approach one, which addresses the problem at the level of interpreting the conduct rules. The second is approach two, which addresses the problem at the level of the tribunal's discretion to make such orders as it thinks fit, having made its findings. And the third is the SRA's approach, which I will call approach three, which is to say that the problem is resolved by the SRA's policy and discretion only to prosecute cases that it regards as serious. That's paragraph 42 of the SRA skeleton, and it was developed by my learned friend. And approach three was, of course, the solution preferred by the judge below at paragraph 77. Just to note one immediate problem with approach three, which has already been, in a sense, identified, is that it can't resolve the problem either when the SRA's own application of its threshold test fails, or in the case of lay applicants, because they're not subject to any internal test. But taking the three approaches in turn and starting with approach one, the construction approach, and responding to some points that my learned friend made in relation to that, you were taken to the regulatory objectives, you'll recall yesterday, in section 1 of the Legal Services Act of 2007. No one is questioning the importance of having rules to protect and promote the public interest and adherence to professional principles and so on. No one questions that, and that is not a new idea introduced by the Legal Services Act of 2007 either, I would say. It's an articulation of an idea which is obtained in this particular disciplinary or regulatory jurisdiction for a long time. But what I do say is that the importance of having such rules does not answer the question as to the conditions that must be satisfied to establish a breach of professional conduct rules that can be disciplined. And my learned friend referred you briefly to section 28(3) of the Legal Services Act, which requires the SRA, when making rules and other things, when carrying on regulatory activities, to have regard to the principles under which regulatory activity should be transparent, accountable, proportionate, consistent, and this phrase is important, targeted only at cases in which action is needed. The reference to that is volume 4, tab 44, page 1255. The SRA, in its submissions, has not explained, I submit, how construing Principle 7 and Outcome 7.5 is being engaged by any breach of any legal or regulatory obligation or legislation relating to the business or the practice is targeting regulatory activities only at cases in which action is needed. The phrase used in section 28(3), subsection, I think it's subsection B, but it's not easy to, it's not hard to find if one finds one by section 28(3). And actually, the problem with my learned friend's case was encapsulated in a phrase he used about 45 minutes ago, where he said, quote, Principle 7 is a top-level principle which is technical in nature. I suggest that's something of an oxymoron, to be talking about a top-level principle that is technical in nature. He also drew your attention yesterday to the fact that Section 31 of the Solicitors Act 1974 enables the SRA to make rules for regulating the conduct and discipline of solicitors, and he placed reliance on the phrase regulating the conduct rather than regulating the professional misconduct of solicitors. But that trying to pass the wording of the Act does not answer, I submit, the question whether, as a matter of construction, professional conduct rules made by the SRA extend to conduct that is less than serious or not reprehensible. Now, my learned friend yesterday afternoon sought to, in a sense, push my client's case into a more extreme position, or to what might be thought to be an extreme position, because he said it was part of the firm's case that the correct approach to construe the SRA's conduct rules should be applied to other professionals as well. And that in some way, the decision we invite you to make can be read across the board to other professionals. That, with respect, is the complete opposite of what we say. This court is concerned only with the interpretation of the SRA's conduct rules, which have their own particular relevant context and history and common law associated with it. The reason why we have referred at paragraph 28 of our skeleton to other disciplinary schemes is solely to make the point that the SRA cannot point to a single disciplinary scheme that does not require some threshold of seriousness or have some threshold of seriousness built into it. My learned friend sought to attack the foundations of the analysis in Lead A, paragraphs 156 to 158, and in particular its reliance on the Scottish case of Sharp. But it's important to see that Sharp itself, though a Scottish case, reflects the position at common law in England regarding the disciplining of solicitors' conduct going right back to the court's inherent jurisdiction, as explained in Myers and Ellman, and as reflected in more recent times in the decision we saw yesterday of Lord Justice May in the Walker case, the one involving the barrister. And it was also suggested this morning that the test adopted in Sharp and also the Divisional Court in Lead A, which referred to whether reputable and responsible solicitors would view the conduct as serious and reprehensible, perhaps reflected a unique Scottish setting. In fact, it's reminiscent, my lords, of language used in English cases, for example, in the context of costs. And you can see this in the extract that the tribunal set out from the judgment of Lord Bingham in the Ridehalgh case. If we can go back, please, to the tribunal's decision at page 239, one can see language used by Lord Bingham, which is very much reminiscent of that used in Sharp, although I'm not sure that he necessarily cited it. We haven't gone back to check, but you see at 9.36 in the middle of the page, reference was made to the Ridehalgh case, where the Court of Appeal described, but it says professional conduct. I understand that it was actually talking about improper conduct in the context of wasted costs. But a similar context, improper conduct which would be regarded as improper according to the consensus of professionals, including judicial opinion. Whether it violated the letter of the professional code or not. So very reminiscent, I suggest, of the language used in Sharp. My learned friend has sought to break the link with the common law by saying that the 2007 Act and the rules made under it were really a new beginning. And he took you to Cordery. You heard my submission about that yesterday, but can I also take you to the introduction to the 2007 Code of Conduct as it was first written, because my learned friend took you this morning to the 2009 updated introduction. But in the supplemental bundle, we have included the original introduction, which you've got at tab 4 of the bundle, page 54, it begins. And page 56 explains why the SRA, which by this time is the new regulator, has introduced a new code. And it's the slim bundle, my lord. It's the supplemental bundle.
Is this all in one place?
It's
Is this the rationale is that we want?
well,
everything
it's
to be-
essentially yes. This involved pulling together the key requirements of professional conduct. This involved the answer to your question is essentially yes. The sentence is this involved pulling together the key requirements of professional conduct. I think there must be words missing, but it must say something like into a codified set of provisions. Nothing about changing the essence of professional conduct or lowering the standard of what may properly be the subject of disciplinary action. Rather, it's simply a new approach. And actually, the words of a new approach was also reflected in one of the other citations my learned friend took you to this morning. None of the citations actually say that we're materially changing the essence of professional conduct and professional conduct rules. In addition, my learned friend, insofar as on behalf of the SRA, he seeks to cast aside the common law under the modern regime, that submission fails to take account of, for example, the central place that the judgment of Lord Bingham as Master of the Rolls and Bolton and the Law Society still has about what the entire purpose of disciplinary action is. In terms of lead A, I submit that if you accept paragraphs 156 to 158 of lead A as being correct, which, as you know, I invite you to do, as stating the general position or the ordinary position in relation to breaches of conduct rules, then I submit the SRA, in the course of its submissions, has not provided you with any satisfactory reason for why the general position should not apply to Principle 7 and Outcome 7.5, which you will remember is, according to the SRA's own conduct rules, simply an explanation of how Principle 7 will be complied with in a particular context. The SRA prayed in aid legal certainty as one of the resulting benefits from its approach. Well, we're not talking about tax legislation or contract law. Professional conduct, by its nature, requires an open-textured approach and a reading of rules which sees them as open-textured standards to be read in the wider context of professional conduct and their common law underpinnings. As regards approach 2, just to remind you what approach 2 is. Approach 2 looks to recognise on particular facts that there has been a technical breach. Let's say if as a matter of construction you accept the approach of the judge. Approach 2 would be say, well, there's been a technical breach of the rule, but the tribunal has a discretion to dismiss an allegation founded on a technical breach. And my learned friend, with respect, has not pointed to anything in the statutory framework which says that the tribunal cannot properly do that. He didn't take the court to the Administration of Justice Act, paragraph Schedule 2, paragraph 16 to 18. It's obvious that the tribunal can dismiss an allegation, that's common ground. There is nothing which constrains the tribunal or prevents it from dismissing an allegation founded on a less than serious rule breach.
When you point to that SGT decision, Pabla, and subsequently more complicated circumstances, Grindwall.
Yes. And I mean, my learned friend's right in a sense that if they're wrong, they're wrong. But we say that they're right because they have a jurisdictional basis, and also importantly, it was a jurisdiction exercised by the tribunal in Lee Day and upheld by the divisional court in Lee Day. The relevant paragraphs, to remind you, paragraph 216, 220, and 236. My learned friend sought to reinterpret that aspect of Lee Day on the basis that the technical breaches in relation to Rule 8 and 9 were conjoined with allegations of breaches of higher level rules about independence and so on. But the tribunal still had to consider each and every alleged rule breach, including the technical ones. And it dismissed them on the basis that, yes, there were breaches, but they weren't serious enough to justify upholding the allegation. And my learned friends, I think, only answer to this point, which isn't really a legal answer, but an answer of mitigation of his client's position, is to say, well, once it's clearly understood that you can be the subject of an adverse finding for a less than serious breach, then any stigma that might otherwise attach will be so much diminished. Well, that reasoning could have been invoked by the court in Walker. The court in Walker, the case about the barrister, could have said, well, we see what the common law is, but we're not going to concern ourselves with the implications of a finding of professional misconduct, because the word will get around that you can be guilty of professional misconduct for less than serious conduct. That with respect, is a back to front way of looking at the point. And in any event, the damage is done by the finding, by the fact of an adverse finding. That's what the public understands. Turning finally, or in terms of the main point, to approach 3, which leaves it all to the SRA's discretion. As I've explained, this is by no means a fail-safe or a satisfactory safeguard. I've explained the problems in relation to judicial review, which my learned friend accepts. There are recent high-profile examples where the tribunal has dismissed cases at the end of a hearing and been highly critical of the SRA. Perhaps the most recent example, the case that was dismissed before and after Christmas, immediately before Christmas, against the solicitor at Carter Ruck, summarily dismissed without hearing the evidence after 5 years of investigating and prosecuting, and the SRA was ordered to pay costs. That's the Gill case. So this discretion under approach 2 does have something materially to add to the SRA's own prosecutorial discretion. And as regards separation of function, there isn't a relevant separation of function, because as my Lord Zacaroli pointed out, the SRA acts as both investigator and prosecutor, which gives rise to an obvious risk that prosecution decisions may be contaminated by the investigation process. So the discretion of the tribunal as an ultimate safeguard to dismiss an allegation founded upon a less than serious breach in order to give a solicitor the complete vindication he or she deserves is very much a salutary one for this court, I submit, to recognise. Turning briefly to ground 2, well, my learned friend has not, this relates to quashing remittal. My learned friend has not answered the basic point that the grounds of appeal, which you have at CB8, page 154, did not challenge the findings of fact.
The appeal to here or
No,
appeal
no,
to
to the
High
appeal from the
Court?
tribunal to Mr.
Okay,
Justice
yes,
Lang.
right.
Grounds of appeal at CB8, page 154, did not challenge the findings of fact or the evaluation of them. And I think you saw this, I think you also understand that in their skeleton argument below, they did not invite the court to remit the matter. The reference for that is CB, core bundle, page 141. It said in terms at page 141 that the tribunal had made all the necessary findings. That's paragraph 45. I think you did see that this morning.
45 of their skeleton.
Below, yes. It's page paragraph 45 of the skeleton before Mrs. Justice Lang, where the SRA made clear to Mrs. Justice Lang that in the view of the SRA, it was not necessary or appropriate to remit the case because the tribunal had made all the necessary findings with which we respectfully agree.
Can you give us the reference for that, please?
Yes, it's paragraph 45, my lord, and it's core bundle, tab 7, page 141. The SRA has not explained in its submissions how any error of law could have affected the findings of fact, nor has it explained on what basis, and this is with the greatest respect to the court below, it's a submission I would rather not have to make, but it has not explained on what basis the court could fairly depart from the agreed position without at least giving the parties the opportunity to make submissions as to whether this was an appropriate course. So that's ground 2. Grounds 3, considering principle 6 and 8. Well, again, there is, to use the word threshold again, a threshold answer to this, and that is grounds principles 6 and 8 were not raised or challenged as grounds of appeal. And the grounds of this, again, the grounds of appeal from the tribunal to the court below. The reference for that is core bundle, tab 8, page 154. I do not accept that the tribunal didn't deal with principles 6 and 8. It clearly did in the passages we referred to earlier. And my learned friend's suggestion that in some way, if you introduce a finding of breach of principle 7 and outcome 7.5, that may have affected the tribunal's assessment in relation to principle 6 and 8 is plainly wrong. Because what the tribunal did have is their own finding of a breach of the MLRs. And it was the breach of the money laundering regulations and the primary facts that supported it, which would have been the essential ingredients of any assessment of whether principle 6 and 8 had been breached. And reading the tribunal's decision fairly, they plainly reached the view that principles 6 and 8 hadn't been breached. And in the absence of any appeal against that finding, there is no proper basis on which it could be included, that is principle 6 and 8, within any remittal. The final point on ground 3 is that my learned friend, I would draw to your attention, has not answered the point that at paragraph 72 of the judgment, page 99, your lordships may want to look at it briefly again. This is the second, well, this is the whole paragraph really, but picking up from the second sentence. The SRA rightly conceded in its reply to the respondent's answer, paragraph 12, the considerations of seriousness were relevant to Principle 6 and Principle 8, it was inherent in the language and content of Principle 6 and 8 that the tribunal were able to consider the additional requirements of seriousness, culpability, and reprehensible conduct. Well, that's exactly what the tribunal did. And in my respectful submission, the SRA has no answer to the point that any error of law, therefore, cannot reach or extend to the decision on Principles 6 and 8. In relation to costs, I think it's common ground between the parties that the appropriate costs order in relation to the tribunal's decision will very much depend on your decision in relation to the other grounds. But again, I respectfully submit there's been no answer to the point that in circumstances where if there's a complete remittal, even then my client may receive a complete acquittal, including in relation to any breach of the MLRs, which would be up for grabs as well on a full quashing. In those circumstances, and given also the possibility, one must assume for present purposes, that the tribunal, whether it be a new panel or the incumbent one, may continue to take the view that the case is beneath the seriousness threshold in the SRA's own policies. In that all being the case, there can be no proper basis or no fair basis for requiring my client at this stage to foot the bill for a 6-day hearing that took place. Well, there was just one other point to respond to a question yesterday about negligence, but subject to that, those were my submissions in reply, unless there are any particular points or questions that the court would wish me to address. Just on, your Lordship may recall yesterday you questioned the proposition, or perhaps not questioned it, but asked me about the proposition that ordinary negligence would not ordinarily sound in an allegation of professional misconduct or be the subject of disciplinary proceedings. And I mean that is the well understood position, certainly, but I don't think I can approve upon what we've already said in paragraph 26A of our skeleton, where we cite the decision of the Court of Appeal in Rea Solicitor, and also Wingate and Evans. I mean, it may assist the court just to look at Wingate and,
Yes.
and Evans for a moment, which is at volume 3, tab 31, page 954. Well, but the extract is page 954. I mean, I'm not sure if all members of the court will be aware, but Wingate Evans was a very important case, both for solicitors and professionals generally, because it considered the meaning of integrity and whether it was different from dishonesty. And there was a lot of argument about, in particular, the SRA scheme, but drawing on, to some extent, other jurisdictions as well. And at page 953,
Yes.
Lord Justice Rupert Jackson at 100 addresses the meaning of integrity. But then over the page at 105, he turns to Principle 6, which is upholding public confidence. And he says that a solicitor acting carelessly, this is the middle of 105, but with integrity, will breach Principle 6 if his careless conduct goes beyond mere professional negligence and constitutes manifest incompetence. And then at 106, in applying Principle 6, it's important not to characterise run-of-the-mill professional negligence as manifest incompetence. All professional people are human. That should perhaps be better understood. And will from time to time make slips, which a court would characterise as negligent. Now, it's true that he's not addressing Principle 5 there, which is the standard which says that you must provide a proper service. He's addressing Principle 6. But the implications of 106 are that Lord Justice Rupert Jackson, who's of course very familiar with the field, well understands that ordinary negligence is not usually the subject of disciplinary action. And if that was his understanding, it is certainly the case. So well, that's all I had to add about negligence. But, can I just check? There's nothing else.
Ask Miss Butler whether she has yet tracked down the predecessor rule to 2024 Rule 1.2b.
Ms. Butler can't find it because it's not online, but we will email it to the court if that's convenient.
Yes, if you would. Thank you.
Or would you like it sent across hard copies?
No, it's fine. If you email to my clerk or someone's clerk a copy, of course, to Mr. Rosen, that will be fine. Thank you very much. Well, thank you to everyone for your helpful submissions, both oral and written. You know what I have to say next, which is we will send out a draft judgment. Draft not in the sense of inviting further submissions unless we do it expressly, but simply for correction of typos, errors of dates and so forth. We will invite consequential submissions in writing, and the contents of the draft judgment are confidential to the parties, that is, those who need to know on the Dentons side, those who need to know on the SRA side, but not for further publication until the judgment is formally handed down in the sense of being promulgated on the National Archive and Bailey websites. Thank you very much for your assistance.
All rise if able. Check a few spellings with you, sir. Gloria. I'll have a look at Nancy.
I can have a look first.
I'll have to see what that looks like. Oh, lovely.